everybody. My name's Peter Wienand. I'm a partner in our intellectual property and commercial team. And I'm going to talk to you about brand protection. But first of all, some housekeeping notes and introductory comments. So welcome to joining this session and to our Entrepreneurs Week 2020, which is a series of 25 virtual sessions on a series of topics. You can find out more about them at our microsite, which is there on the screen. Hopefully you can all see the slide there. So Entrepreneurs Week is part of our focus on private business, family businesses, entrepreneurs and investors. Thanks for signing up for this session. You can join the conversation about eWeek by using the hashtag and tagging us on LinkedIn, Twitter and Instagram there. Just for those of you who've arrived in the last couple of minutes, a reminder that there is a final session closing up, wrapping up our Entrepreneurs Week on Friday at 5 o'clock, an hour of cocktails and networking with some fantastic prizes donated by some of our clients. I'm sure you're all used to this by now, but do please keep yourselves on mute while I'm talking to prevent any audio feedback. There will be an opportunity for questions later on. And if you want to jot down a question so you don't forget it, please do jot something down into the chat box, and I'll try and catch up with those questions at the end. And finally, the session's being recorded so we can share this with all of our clients. And that recording, and indeed recordings of all our sessions, will be available with key takeaways on the microsite, the web address of which is there on the screen. So thank you for that, for listening to the opening remarks. So today we're talking about brand protection. Brands and trademarks are very much in the news at the moment, as you'll have seen from references to Messi succeeding in getting his trademark application through against an opposition, and Banksy's Flower Power trademark application failing in the face of an opposition in the EU trademarks registry. Interesting that both of those items are not just about brands, but actually also about the system of trademark registration, which I'm going to talk a bit more about later on. But why is protecting your brand important? Well, there are 4 reasons that I've put up there, which I think are probably familiar to most of you. First of all, recognizability. A brand identifies your products and services so they can be seen in the market and can be distinguished from those of your competitors. So a good brand serves not just a function of recognizability, but also differentiation. Second thing is a good brand attracts. Once recognized, it can help attract repeat customers who can refer other customers. And it can also, through this process of attraction, create emotion. It can create an emotional bond between your products and services and your customers. And that emotion is absolutely key because it supports a higher price point and profit margin. The emotion behind a brand is the irrational aspect which enables you to charge a higher amount for your products and services than you would without it. So it boosts profitability, and finally, of course, all those things add to the value of your business on the balance sheet. And in fact, brands and trademarks are balance sheet items. So that's why it's important to protect your brand. Just before we talk about how you protect your brand, let's just have a look at what is a brand as background to what you can protect legally. So there are all sorts of things that can be brands, the most common of which obviously are names and logos, but shapes can be brands as well. A couple of examples there, both of which also happen to be registered trademarks, one belonging to Cadbury and the other to Aston Martin. And colours can be brands as well. Cadbury's purple colour is a recognisable brand element, although they failed to get that registered as a trademark. But a successful trademark registration for a colour is shown there on the slide, the Louboutin red sole for the Louboutin shoe. And once once established, a brand can become synonymous with the products and services of a given business. So very powerful, although there are dangers if a brand becomes too synonymous and becomes descriptive or generic. I'll come back to that a bit later. So those are the sort of things that people think of first and foremost when talking about brands. But of course, brands can have a broader meaning. And if you talk to brand consultants, marketing consultants, here's one example on how he defines a brand. Brands can be given a much broader definition than just, if you like, the tip of the iceberg stuff that we're concerned with, names, logos, shapes, and so on. Brands can embrace all the interactions that you have with your customers. In this definition, the set of values, traits, and beliefs that makes a product or a service consistent and distinctive. All your interactions with customers have the potential to feed the brand and give it meaning. Classic examples are lifestyle and luxury brands, but also retail and leisure, where the environment and how staff deal with customers also become part of the wider brand. But against that background, what does the law protect, and what are we therefore concerned with today in terms of how you protect your brand in legal terms? So the law, and I'm talking about English law, but some of this is harmonized across the world through international IP treaties. The law protects these three things that are relevant to brands. The first is that the law protects goodwill through a common law system of unfair competition protection called passing off. So the way this works is that you have a right to be free from competitors misrepresenting their business or products or services as yours. This is the common law of passing off. It's essentially the only way to protect an unregistered trademark, unless you also happen to have copyright in the logo or a design, some form of design protection. And it extends beyond brands to cover endorsement claims. So where somebody claims an endorsement which they're not entitled to claim. So in that respect, it's a flexible form of protection, but there are some significant disadvantages in simply relying on the common law of passing off as against having a registered trademark. First of all, a key disadvantage with relying on passing off is the evidential burden. In order to prove passing off, you have to show that customers have been confused as a result of a misrepresentation. And that is a difficult thing to do, and the courts are reluctant to accept certain types of evidence that are designed to show how customers have been confused. So it can be quite difficult evidentially to prove passing off. Another disadvantage of relying on unregistered rights in the form of passing off rights is that there's no way of searching them. There's no register. There's no way that anybody else can be told that you have rights, the rights that you claim in your logo or in your name. So as against the common law system of protection, the registered trademark system has mirror image advantages. The first is that registered trademark infringement is much easier to enforce than the passing off action. You don't have to get evidence of confusion and misrepresentation. And registered trademarks can be searched for. They are public instruments that appear on a trademarks register and tell the world that you have the rights that you claim in your trademark. There is a cost attached to getting trademark registration, but that cost is relatively modest unless you need to register more than one mark for more than one type of product or service in more than one country. And if each of those factors ratchets up, then obviously the cost can increase. But most trademark registration budgets reflect the current scope of the business and are perfectly affordable. And as I also mentioned, registered trademarks are a form of property. You get a certificate, unlike passing off rights, which are not really a form of property at all. Obviously, goodwill is a form of property which appears on balance sheets and is the subject of business transfers, but it's not the same as a registered trademark, which is certificated and evidenced by a public registration a public register. Just before moving on from registered trademarks, which are essentially the main way of protecting a brand legally, there are other forms of intellectual property which we shouldn't forget, because they can provide adjunct or ancillary protection which can be useful. Copyright protects artistic works and literary works. Now, in the sphere of brands, that's most relevant to logos. Most brands just consist of to the extent that their names just consist of a word or a few words, which would not be protected by copyright. But a logo can be protected by copyright, and so that can be helpful, although copyright infringement needs proof of copying. So in order to allege that somebody has taken your logo, you need to show that they've actually copied it. And sometimes that's not easy to prove, and sometimes they haven't. They've come up with a similar design and there's been no copying involved. So as against that, having a registered trademark is definitely more advantageous. And then there are various forms of design protection that protect the shapes of products, which can also provide some form of ancillary protection for brands which take the shape of a product design, such as the Aston Martin automobile design I showed you before. So those are the forms of legal protection, but as I say, registered trademarks are by far the best and most powerful form of protection for a brand if you can get registration. I should just mention in passing that company and domain names in themselves provide very limited protection. We're often asked, what protection does our company name or our domain name give us? And the answer is not much. A bit, but not much. So far as a company name is concerned, it's very limited. Companies House only blocks identical names from being registered, and the company name isn't really in itself a form of intellectual property. Domain names aren't really a form of intellectual property either, although they may reflect intellectual property. They may of course reflect a brand. The domain name may include the brand in it. But domain names are capable of multiple variants. Suffixes make that much worse. There are dispute resolution policies that apply to people using your domain name or using a name similar to your domain name in an unauthorized way. But most of those dispute resolution policies, including the leading one, which is the World Intellectual Property Organization's Uniform Domain Name Dispute Resolution Policy, the UDRP, essentially rely on a complainant showing that they have an entitlement to the domain name which derives from a superior legal right, and that is usually a registered trademark. So don't think that simply because you've got a domain name or a company name, that is going to give you a lot of protection. You really need to get a registered trademark to back it up. So some of you may be operating under a brand, others may be about to adopt a brand or maybe rebranding. But the first step, as you'll have taken from the previous slides, is in brand protection strategy is to try to get a registered trademark. The second step is to choose a mark, which makes it easier for you to protect the mark and easier for you to register it. So I'll just spend a few minutes talking about choosing the right mark. The first dimension to choosing the right mark is choosing a mark which is distinctive, which helps to differentiate your products and services. Remember that one of the key functions of a brand and one of its key values is its ability to differentiate your products or services, your business, from those of your competitors. And that's reflected in the legal system. The legal system has a built-in bias in favor of differentiation and does not favor marks that are less good at differentiating your products and services. So, for example, the trademark system, and this is enshrined in the Act, the Trademarks Act, makes it difficult to register marks that describe products or services. So, for example, if we try to register legal services as a trademark, that would be knocked out immediately because it just describes what we do. Marks that describe geographical origin are also difficult to register. So if we try to register London in relation to what we do, that would also be knocked out because there are lots of other lawyers in London who want to use the name London to describe where they practice. marks designating quality like fantastic and similar laudatory epithets, they can't be registered. And marks that have become customary to describe products or services are also, in principle, unregisterable. So that's a warning sign about using marks that are too descriptive of what you do or of what your products or services are or of where they come from. But there is an important but here. Such objections can be overcome through use. If you've been using your mark for a long period of time in such a way that your customers associate your products and services with that mark, and it serves to differentiate your goods and services from your competitors, then the registry may be persuaded by evidence to that effect, evidence of investment, turnover, advertising, and so on, which shows that in the marketplace, your mark does serve to differentiate. A good example of that is the trademark Zurich. The name Zurich is actually a registered trademark belonging to the Zurich Assurance Company. And although it's also the name of a city in Switzerland, it is registered for financial services by Zurich Assurance. So they can use that name to stop others using the city name in relation to financial services. Sometimes you can bolster protection where you have descriptive elements in your mark, and I've given an example there on the slide. This is a registered trademark belonging to another financial services business called Longfield Investment Partners. The distinctive elements there are the logo and the name Longfield. Investment Partners are obviously descriptive terms and would be hard to register on their own. You couldn't monopolize those words, but in combination, that works well as a mark and is perfectly registerable. So that's step one. Step two in choosing the right mark is obviously to try to avoid using a mark that is too close to somebody else's, because if you do, they will stop you, or there will be confusion in the marketplace and your mark will not really serve the purpose which it should of differentiating your mark from that of competitors. Now, of course, I'm conscious that there are some people who think it's quite a good idea to use a similar mark to somebody else's because they actually want to purloin an existing business's goodwill and or customers, but of course there are risks in doing that, because if somebody has prior rights, they can stop you, and if you're trying to register your mark, they can block your trademark application. Now, just while talking about opposing your trademark application, gives me an opportunity briefly to touch on the question of classification. Trademark registration system is built on classification of goods and services. All the goods and services in the world are subdivided into 45 classes, and you can only register your trademark in relation to the goods and services on which you are actually going to use your mark. You can't just have a blanket registration unless you can genuinely show that you're going to use your mark in relation to all of those goods and services. There are some marks that have extremely wide coverage in all sorts of domains. Rolls-Royce and Disney Studios are good examples of that. They've registered their marks in 20 classes for Rolls-Royce and 29 for Disney Studios, and that's because they have wide merchandising activities and operate in a very wide range of spheres. So in order to avoid running up against earlier rights that belong to somebody else, it's wise to do some sensible due diligence, little bit of searching of the register, bit of checking online, so that you've identified whether there are any earlier rights that you might be conflicting with that might make it difficult for you to get a registration for your own brand. So you've chosen your brand, hopefully you've registered it, and I'm now going to talk about what you do when you've established your rights, how you then protect your brand through maintenance and defense. There are four key elements to this, what I call four golden rules to maintaining and defending your brand. Licensing the brand or the mark, using it, monitoring use by others, and prosecuting unauthorized use when you come across it. There's little point in spending money on developing a brand and then registering it if you don't work to maintain it. So it's a bit like land. If you don't look after your land and put fences around it, squatters will come in and you'll lose not only rights over the land, but the land will lose its value. So to look at each of those in turn, licensing. Not all uses need to be licensed. Only uses where somebody is using the mark to identify your products and services need to be licensed. If a distributor or retailer is simply using the mark to describe your products or services in the normal course of selling them, they're just identifying your goods or your services. That's not necessarily a use that needs to be licensed. But if somebody is actually being permitted to apply your mark to their products or their services, that certainly needs to be licensed. And if you don't license that third party explicitly, they will begin to acquire rights against you. They will then be able to assert those rights and say, well, you've permitted me to use your mark. I have now acquired some rights in the mark and you can't now stop me. There is a risk of that happening over time. And if that happens, then the rights in your mark become diluted and eventually you might even lose the mark altogether. So you need to be astute to when it is necessary to license your mark. And if you have a registered trademark, that license needs to be in writing. If it's not in writing, it's not a binding license. So you need to have a form of trademark license with appropriate protections to use in those circumstances. The next element to maintaining and defending your brand is using it. If you don't use your mark over a continuous period, again, you will lose it. The period of non-use which makes your mark vulnerable or your registration vulnerable is quite. You would think that the chances of this happening are remote. In fact, it's not as remote, especially with sub-brands or subsidiary registrations, subsidiary trade, as opposed to the main. Or it can happen, it very frequently happens where you have a mark that's registered for products or services, and the mark simply doesn't use the mark in relation to one or two of those products or services. You can then have a situation where that mark becomes partially vulnerable to revocation. So the registration that covers the goods or services for which it hasn't been used is whittled down as a result of a revocation application, and the rights in the mark are narrowed as a result. So it is really a question of use it or lose it. And in the case of unregistered trademarks, if you don't use the mark, then obviously the goodwill will eventually erode and fritter away and disappear entirely. So you'll never be able to rely on a passing off action. The quality of use is important. It's not just the quantity of use, but the quality of use is important in a couple of ways. Firstly, in relation to marks that are more descriptive of their goods and services. So, for example, the Longfield Investment Partners mark that I mentioned before, or other marks that are even more descriptive than that. It's important to make sure that you're using that mark as a trademark and you're not using it too descriptively in relation to your goods or services, because that will undermine its distinctiveness and ability to differentiate. And the other way in which you use a mark can create risks is if a mark becomes so successful that it becomes the name for the product or service in question. And such marks are called generic marks. And a good example of what can happen is Hoover, which was registered for vacuum cleaners and eventually became synonymous with vacuum cleaners. And there was a risk of the owner of the trademark losing any right to use it as a trademark, because it had become a descriptive generic term that everybody was using, almost a dictionary term. They managed to prevent that from happening, but only after a very, very expensive campaign of preventing people from using the word in a generic way. Just as a brief aside, here is an example of what happens if you apply to register a trademark where you have no intention of using it. So this is the Banksy Flower Power logo. He, or rather his company, applied to register this as a trademark, but had no intention of actually using it as a trademark. In fact, he admitted that he had no intention of using it as a trademark, and had permitted many people, including greetings cards companies, to use the image. And one of those companies opposed his application and successfully persuaded the European Intellectual Property Office to block the application on the basis that Banksy had no genuine intention of actually using this as a trademark. The third dimension of maintaining and defending your brand is monitoring the use of the brand out there in the world by others. And clearly, you can invest a great deal of time and effort and money in monitoring other people using your mark. And so what you need to do is to determine the right level of investment, which is proportionate to the risk. And there are certain things that you can do that make life easy and reduce the amount of investment. So just coming back to the advantages of trademark registration, one of the advantages, as I mentioned, is that your brand, when it's registered as a trademark, appears on the register, a public register, and that's open to the world, and people can see that you're claiming rights. But it also serves as a block to other people trying to register conflicting marks that conflict with yours because they are similar to it. And in those circumstances, you will be notified of such conflicting applications by the trademark registry. So that is one of the advantages of registration. The trademarks registry performs a limited degree of monitoring, if you like, on your behalf where your mark is registered. That's not absolutely foolproof, and it's not universal, and it doesn't cover use in other territories. And if you want to invest a bit more money in monitoring what other people might be doing in other registries, then you can pay for watch services, which are available for early warning and which cover other countries. But that only deals with spotting other people filing trademark applications for marks that are identical or similar to yours. It doesn't necessarily tell you about what other people are doing out there in the world, not in the trademarks registry, but actually in the marketplace. And you need to find ways of understanding what they might be doing. So here, technology can definitely assist, and you can do a certain amount of DIY monitoring using Google Alerts. There are more sophisticated products available that you can sign up to. For example, there's something called Brand Pulse, which is a product developed by a data insight company called Data Pulse, which provides a sophisticated data insight-driven service, which is focused particularly on domain misuse. And there are other services like that. But Google Alerts is good and powerful. It can be set up to notify you of uses of your brand, and most importantly, it can also be set up to notify you if people are using your brand as a keyword or a meta tag. This is not something that you would necessarily know otherwise, because that use is subliminal. At least it's not something that's explicit, and I'll come back to that later. And then in certain industries, you need to go further. So in fast-moving consumer goods and luxury, counterfeiting is a critical issue, and there your monitoring needs to be even more extensive. The law does recognise the risks involved with counterfeiting, and there is a whole regime where you can notify the customs authorities to undertake border monitoring on your behalf. You can also notify the police and trading standards officers, and they can undertake a certain amount of monitoring on your behalf, although their resources are currently very limited. But those are options as well. I just would make a quick note: if you're in those industries at the moment, you need to be preparing yourself for dual track border monitoring because of Brexit, because the system is going to bifurcate after the 31st of December. So that's monitoring. And finally, if you come across somebody who's using your mark, and it's not somebody that you've authorized or want to authorize, so it's not somebody you'd be licensing, it's an unauthorized use, then you've got to stop it. You must not tolerate infringements. As I said before, if you allow people to use your mark without stopping them, eventually that will erode your mark. It risks diluting your rights. People will get squatters' rights in your mark, what I call squatters' rights, and eventually your mark, the rights in your mark will be eroded to such a point that it'll become unenforceable and useless, and it will have no value. So you've got to take steps to stop unauthorized uses. But it's not necessarily about litigation, at least not initially, except in cases where an immediate injunction is necessary to prevent irreparable and imminent harm. In most cases, it's simply a question of sending a firm letter, but you can't just chuck around cease and desist letters at random, because you need to make sure that the claim that you're making is properly framed, and there is a risk, if you don't do that, of a counterclaim for issuing groundless threats of infringement. So it's important to get advice. That advice at the stage of an initial letter is not expensive. It's just an initial letter. And in many, many cases, that's sufficient to stop the unauthorized use. Another good reason for getting advice is that not all uses necessarily infringe. And it's important to know whether something that is out there is actually an infringement or not. I mentioned meta tags and keywords before. The law around keyword use and meta tag use is complicated, but many uses of keywords or meta tags on the internet are not necessarily infringement if there's no confusion as to the source of products or services. So that's another good reason to get advice early. Finally, I should mention that in the worst case of counterfeiting, that's to say where somebody is using your mark not only without authority but knowingly misusing your mark in order to obtain gain for themselves or to divert your customers, that is an offence. It's known as counterfeiting, and in those circumstances, you can refer the matter to the police, who interface. There's an interface here between the intellectual property protection system, trademark and brand protection system, and serious and organised crime and cyber crime. Doesn't apply to all cases, obviously. It's particularly relevant in fast-moving consumer goods, luxury, and so on. And as I said before, the police have limited resources, and they don't like people trying to enforce private rights through the criminal justice system. But in certain cases, this is a helpful adjunct to the brand protection system. So just to sum up, key takeaways for protecting your brand: first of all, choosing the right brand in the first place, getting it registered if you can. Then once you've got a registered trademark and once you've chosen the right mark, licensing uses where you want to permit those uses. Make sure you use the mark, use it in the right way, monitor the marketplace to see what other people might be doing with your mark that you might need to stop. And if you find unauthorized uses, then take firm and determined steps to prosecute, to stop those unauthorized uses from eroding the value in your mark. So thank you very much for listening. I hope that was helpful. And we have time now for some questions. If you'd like to ask a question, I'm going to end the slideshow right now. If you'd like to ask any question, do unmute or send a question through on the chat facility. While waiting for anybody to pose a question verbally, I have got a question that's being posed through the chat function, which is a question about including all the potential parts of a mark, this is a question that's been posed to everyone, so I take it it's okay to mention the mark, which is PhysioFast Online, and the questioner has said that they've trademarked PhysioFast but not added the online bit. So this is quite like the Longfield Investment Partners registration that I mentioned in my slides, my answer to that question would be that you could have added online to the trademark application, but online is like the words investment or partners in the example. It's a commonly used term that's descriptive of an aspect of the goods or services, and so even if you had included it and got it registered, it wouldn't really count as a distinctive part of your mark. So I don't think you've lost anything by not including the distinctive part of the mark is clearly PhysioFast, which is not a phrase that you used. It's not a dictionary term, and although it's made up of common words, that combination mark. That's fine. I've got a couple of other questions on chat. A good question about where you've got a word mark already registered. Does that make it easier then to register a visual mark? Not necessarily. It depends on whether the visual mark, whether you're relying on evidence of use of the word mark in order to register the visual mark. What we sometimes advise people who've got a name that is perhaps slightly descriptive and also a logo is to file an application to register the two together as a combination, because that's easier to register and it's also less expensive because you're only filing to register one mark rather than two. The one caveat